Book 2, The Lands of California. Stave 1. How far land monopolization has already gone. In all the new states of the Union, land monopolization has gone on at an alarming rate, but in none of them so fast as in California. And none of them, perhaps, are its evil effects so manifest. California is the greatest land state in the Union, both in extent, for Texas owns her own land, and in the amount of land still credited to the government in department reports. With an area of 188,981 square miles, or, in round numbers, 121 million acres, she has a population of less than 600,000. That is to say, with an area 24 times as large as Massachusetts, she has a population not half as great. Of this population, not 1/3 is engaged in agriculture, and the amount of land under cultivation does not exceed 2,500,000 acres. Surely land should here be cheap, and the immigrant should come with the certainty of getting a homestead at government price. But this is not so. Of the 100 million acres of public land, which, according to the last report of the department, yet remain in California, which of course includes all the mountains and sterile plains, some 20 million acres are withheld from settlement by railroad reservations, and millions of acres more are held under unsettled Mexican grants, or by individuals under the possessory laws of the state, without color of title. Though here or there, if he knew where to find it, there may be a little piece of government land left. The notorious fact is that the immigrant coming to the state today must, as a general thing, pay their price to the middlemen before he can begin to cultivate the soil. Although the population of California, all told, miners, city residents, Chinamen, and diggers, does not amount to 3 to the square mile. However, the arable land of the state has hardly been scratched, and with all her mountains and dry plains, California has an arable surface greater than the entire area of Ohio. It is already so far monopolized that a large part of the farming is done by renters or by men who cultivate their thousands of acres in a single field. For the land of California is already to a great extent monopolized by a few individuals who hold thousands and hundreds of thousands of acres apiece. Across many of these vast estates, a strong horse cannot gallop in a day. One may travel for miles and miles over fertile ground, where no plow has ever struck, but which is all owned, and on which no settler can come to make himself a home, unless he pays such tribute as the lord of the domain chooses to exact. Nor is there any state in the Union in which settlers in good faith have been so persecuted, so robbed as in California. Men have grown rich, and men still make a regular business of blackmailing settlers upon public land, of appropriating their homes, and this by the power of law and in the name of justice. Land grabbers have had it pretty much their own way in California. They have molded the policy of the general government, have dictated the legislation of the state, have run the land offices, and used the courts. Let us look briefly at the modes by which this land monopolization has been carried on. The Mexican grants. California has had one curse which the other states have not had: the Mexican grants. The Mexican land policy was a good one for a sparsely settled pastoral country such as California before the American occupation. To every citizen who would settle on it, a town lot was given. To every citizen who wanted it, a cattle range was granted. By the terms of the cession of California to the United States, it was provided that these rights should be recognized. It would have been better, far better, if the American government had agreed to permit these grant holders to retain a certain definite amount of land around their improvements, and compounded for the rest of the grants called for by the payment of a certain sum per acre, turning it into the public domain. This would have been best, not only for the future population of California, but for the grant holders themselves, as the event has proved. Or, if means had been taken for a summary and definite settlement of these claims, the evils entailed by them would have been infinitesimal compared with what have resulted. For it is not the extent of the grants, and, all told, the bona fide ones call for probably 9 or 10 million acres of the best land of California, which has wrought the mischief so much as their unsettled condition. Not the treaty with Mexico, but our own subsequent policy. It is difficult in a brief space to give anything like an adequate idea of the villainies for which these grants have been made the cover. Suppose the history of the Mexican grants of California is ever written. In that case, it will be a history of greed, of perjury, of corruption, of spoliation, and high-handed robbery, for which it will be difficult to find a parallel. The Mexican grants were vague, running merely for so many leagues within certain natural boundaries, or between other grants, though they were generally marked out in rough fashion. It is this indefiniteness that has given such an opportunity for rascality. It has made them such a curse to California, and which, at the same time, has prevented, in nearly all cases, their original owners from reaping from them any commensurate benefit. Between the Commission, which first passed upon the validity of the grants and final patent, 1,000 places were found where the grant could be tied up, and where, indeed, after 23 years of litigation, the majority of them still rest. Ignorant of the language, of the customs, of the laws of the new rulers of their country, without the slightest idea of technical subtleties and legal delays, mere children as to business, the native grant holders were completely at the mercy of shrewd lawyers and sharp speculators. At a very early day, nearly all the grants passed into other hands. How the grants float. As soon as settlers began to cultivate farms and make improvements, the grants began to float. The grant holders watched the farmers coming into their neighborhood, much as a robber chief of the Middle Ages might have watched a rich Jew taking up his abode within striking distance of his castle. The settler may have been absolutely certain that he was on government land, and may even have been so assured by the grant holder himself. Still, so soon as he had built his house and fenced his land and planted his orchard, he would wake up some morning to find that the grant had been floated upon him and that his land and improvements were claimed by some land shark who had gouged a native Californian out of his claim to a cattle run, or, wanting an opportunity to do this, had set up a fraudulent grant supported by forged papers and suborned witnesses. Then he must either pay the blackmailer's price, abandon the results of his hard labor, or fight the claim before Surveyor General, courts, Commissioner, Secretary, and Congress itself, while his own property, parceled out into contingent fees, furnished the means for carrying the case from one tribunal to another, for buying witnesses and bribing corrupt officials. And then, frequently, after one set of settlers had been thus robbed, new testimony would be discovered, a new survey would be ordered. The grant would stretch out in another direction over another body of settlers who would then suffer in the same way. In many cases, as soon as one grant had been bought off or beaten away, another grant would come, and there are pieces of land in California for which 4 or 5 different titles have been purchased. The ruling of the courts has been that so long as the grants had not been finally located, their owners might hold possession within their exterior boundaries and eject settlers. Thus, if a grant is for 1 league, within certain natural boundaries, which include 50 leagues, the claimant can put settlers off any part of the 50 leagues. Whenever any valuable mine or spring is discovered in the neighborhood of any of these grants, then the grant jumps. If they prove worthless, then it floats back again. Thus, the celebrated Mariposa claim, after 2 or 3 locations in the valley, was finally carried up into the mountains, where it had as much business as it would have had in Massachusetts or Ohio, and stretched out into the shape of a boot to cover a rich mining district. Among the property given to John Charles Fremont and his partners by this location was the Ophir Mine and Mill, upon which an English company had spent over $100,000, after assurances from the Mariposa people that the mine was outside their claim. In the southern half of California, where these grants run, there has been hardly a valuable spring, or mine discovered that was not pounced upon by a grant. One of the latest instances was the attempt to float the Cuyamaca grant over the new San Diego mining district, and to include some 65 mines, one of them, the Pioneer, on which $200,000 has been expended. Another was the attempt to float a grant over the noted Geyser Springs in Sonoma County. In both these cases, the attempt was defeated, General Hardenberg refusing to approve the surveys. In the latter case, however, it was dog-eat-dog, the great script locator, W.S. Chapman, having plastered Sioux Warrant over the wonderful springs. He has since obtained a patent, though I understand that somebody else laid a school land warrant on the springs before Chapman.